all see this link. This is the link that shows the data that is collected from CMS CWMS, which is the database that is used by the California social service departments throughout the different counties. And then the data is taken from that database and collected by UC Berkeley and then put into different data sets. So here's the link. And then I thought just quickly, I would also show you the website. So if you click on these links, then you can, it'll take you to this website here. And this is where you can get information about ICWA cases. If you scroll down and click on, let's see, this one here, 4E 1 and 2, ICWA placement preferences. That one shows where Indian Child Welfare Act cases, what the children's placements are. And there's a new feature, removal reason. So that's exciting. And then also if you go up here and you go to rates and you click on the disparity indices, this is where you'll get your the data that I was using to show disparities. So I used the in-care on July 1st, 2003, but you can look at allegations, sub-allegations, entries, anything you want. So as you can see, this website is just full of data. So hopefully some of you will have some time to kind of explore it and see what's out there and check on your county and how they're doing. If anybody misses this link, Stephanie can provide it later, or I don't know, I think it'll be available online. So here's the link for everybody. If you go to this link, which is a shorter one, then you need to just click on the measures button. And if you go here, this is the full link that'll take you right into where all the data is. Okay, so hopefully that is helpful. We did have just one, I guess it was not really a question, it's just another statement from the CILS MARC team. And it's that in the definition of foster care in the Indian Child Welfare Act, which is at section 1903, so we've been focusing on section 1912. Section 1903 is all the definitions, and the first definition is for foster care placement, and that definition says foster care placement, which shall mean any action removing an Indian child from its parent or Indian custodian for temporary placement in a foster home or institution or the home of a guardian or conservator where the parent or Indian custodian cannot have the child returned upon demand, but where parental rights have not been terminated. So in that definition, it doesn't talk about at what point in a proceeding is the removal and temporary placement triggered. So, you know, I think there is room to argue that the child is being removed as early as the detention hearing. And if enough people make that argument and enough courts find that that is actually where foster care placement is happening, then I think there'd be a strong argument in the future for requiring expert witness testimony as early as detention. I know currently it seems like social services and courts, for the most part, are treating that foster care placement as being at the disposition hearing. So I don't think it's clear in the law whether foster care placement happens at detention or at disposition. I think it seems to me that Mark Radoff believes that it definitely is triggered at detention. I'm not sure that I agree with that, but I think there's a legal argument for that. So, and that's, you know, welcome to the law. There's a lot of questions out there as much as there are answers. So I think it's up to everybody to argue with what is in your client's best interest or in your community's best interest or in your family's best interest, depending on who you are in the case. And, you know, if you're persuasive with the court, then that could be setting precedent for the next case that comes. So it's definitely something to consider, is when is that foster care placement actually being made? Going back to 1912, just so we're clear, Section E that deals with foster care placements does say that no foster care placement may be ordered in such proceeding in the absence of a determination supported by clear and convincing evidence, including the testimony of a qualified expert witness, that the continued custody of the child by the parent or Indian custodian is likely to result in serious emotional or physical damage to the child. So I guess the trick is that it's no foster care placement may be ordered. So when is the court actually ordering foster care placement? And that seems to be where the legal debate could set in. So I hope that's clear. I'm not sure I gave you a definite answer, but at least you should be clear on the different arguments I think that could be made in a case involving an Indian child. So are there any other questions on that before we move on?
Any questions on that? Does everybody understand what she was clarifying on? If you recall, we were talking about the difference between placement, the terms like emergency removal versus a placement or removal, and we were talking about how there's different processes of when the court is. That's what she's referring to. And what Mark Radoff was pointing out, that there's a legal argument that can be made that an emergency removal of a child is a removal under ICWA, and so a qualified expert witness should be used. What Christine was saying is that it's not clear, it hasn't been definitively determined under the law. Right now, the state courts are looking towards the part that says when the court orders placement, so that it's at disposition, so the child could be removed for emergency removal a substantial amount of time, but the court hasn't technically ordered a removal until the disposition hearing, and therefore the court's argument or the state's argument or whoever is removing the child might argue the qualified expert witness wasn't required until there. The counter argument is that whenever the child is removed from the home, it's considered a removal and you should have a qualified expert witness. There's no definitive legal answer, but what Christine was pointing out is you can make either argument. You make the argument that's best for the Indian child utilizing the act. If there's more people arguing that the emergency removal or that detention hearing removal is an ICWA removal, then that might create the case law needed to make that the standard. Or if court rules are changed or the California ICWA is created to make that definition. Hopefully that clarified things a little bit more and not worse. But does that make sense to everybody? I see some heads nodding yes, but that could just mean stop talking. Okay, excellent. Are there any questions with that? Okay, then Christine, I'm going to let you continue.
Okay, so hopefully everyone got this link. We're going to go back to the slideshow now. And there we go. So moving on, now we are going to talk about who can qualify as an expert witness and what to look for in a qualified expert witness. So, for the qualified expert witness, first of all, it is determined on a case-by-case basis. So what we're going to talk about are the most likely persons. And that's sort of the best answer we can give because, like I said, and this is true with a lot of child welfare proceedings, at least in California, the law is purposely vague in areas to allow for a case-by-case determination, which can be good or it can be bad. So most likely persons, I would say first in the list would be a member of a tribe, preferably with knowledge of the child's tribe, family organization, and child rearing customs. So I'm sure each of you can think of an example in your head of someone that might meet that standard. Maybe it's an elder. Maybe it's the tribe's historian. Maybe it's the tribe's Indian Child Welfare Act worker. It could be any number of people, but it should be preferably someone with knowledge of the child's tribe's customs. Second in the list is the expert in the delivery of child and family services to Indians and tribal customs. So here, I guess the difference would be, it's not necessarily someone who's a member of the tribe or a member of the community, but they have some expertise in the delivery of child and family services to Indians. And so that would be, again, like someone who works for, let's say, a nonprofit that specializes in providing services to Native children and families. It could be someone who works at maybe the Native American Health Clinic that's local to this child's tribe. I'm sure each of you can think of someone who is an expert in the delivery of child and family services, specifically pertaining to Native American families. And then last on the list is a professional person with substantial education and expertise in their specialty or field. So you can see the list goes from specific to broad. And the last prong there is very broad. And so I'm expecting to get a lot of comments from CILS in the audience, just if we're going to keep consistent with tradition here. But I will say there's been a lot of legal uncertainty about how this list should be treated in court. So there are those of us who would argue this list is in order, with the first one being the first preferred person, and then going down from there to the second most preferred, and then the third. I know cases where that argument has lost, and the court has found that you can start with number 3 and make an argument that a professional person with substantial education and expertise in their field, who may or may not have any knowledge of the child's tribe's family organization, is just as qualified as number 1. So again, biased. I tend to read. So I do think, and I also have exclusively represented tribes.
Christine?
Yes.
We just lost you when you said, I tend to think.
Okay. Am I back?
Yes, you're back.
Okay. So I'm not exactly sure where I was when we got lost, but I'll just repeat that I tend to think that numbered lists are numbered for a reason, and they are in order of preference. Additionally, I am biased, and I've spent my career as an attorney representing tribes. So I do favor that a qualified expert witness in an Indian Child Welfare Act case should be someone with knowledge of the child's tribe's customs and traditions around childbearing. But I wanted to warn everyone that being said, there is case law stating that a professional person who doesn't have any of that tribal knowledge or experience can be qualified to serve as an expert witness. And specifically, there have been cases where in the underlying allegations of the abuse or neglect, so the reason that the child was being removed from their family in the first place, if those reasons were something that didn't have anything to do with any child-rearing customs, then the argument to use any professional person becomes stronger. And that's what some courts have found. So for example, if the child's being removed for the parent's addiction to drugs and alcohol, then some people have argued this is more about what the child has experienced and suffered, and has nothing to do with any child-rearing customs, because abuse of illegals and substances and alcohol was never a part of any tribe's customs. So you can see where, again, we have sort of an unsettled issue in law. I would say that when we do have an issue that is related to child customs, child rearing customs of a tribe, then it would be tough to accept a professional person who doesn't have any experience in any kind of child rearing customs for that tribe. But I have to say, unfortunately, I have seen courts do just that. So, could a professional person with substantial education and expertise in their specialty or field be, say, a professional plumber? I don't know. I can't see how that would ever be applicable in any case. So I think there are some limitations, and it's really going to be up to each person to argue for what qualifies an expert in each individual case. And the courts are supposed to be making that determination on a case-by-case basis, depending on the facts of the case. So with this most likely persons list in mind, moving to the next slide, is a formal education required? And this slide comes out of just some personal experience of mine of presenting someone who was an expert, considered an expert in their tribal community about the child rearing practices of their tribe, and having that person be challenged because they didn't have an education past, say, graduation from high school. And there's no requirement in the law that the expert witness needs to have any kind of specialized degree or education. It's really a knowledge-based requirement, not an education-based requirement. Okay, so what knowledge is required? The expert witness, the qualified expert witness, must be able to determine two things based on their knowledge as an expert. First, they should be able to determine the tribe's cultural, social, child rearing standards. And this can come from experience by living in the community, growing up in the community, being revered as an elder by the community, or it can come from study. So either mentoring under someone else or a formal study through some kind of degree program or other education or training. And then they should also be able to determine the risk to the child if they remain in the home. And that knowledge is going to come from research or investigation regarding the facts of the case. And we're going to talk more about that later, but I did just want to lay out those two things are sort of the minimum that the experts should be able to be knowledgeable about. So one of those is going to come before the case starts, that tribal, cultural, child rearing standard, the knowledge around that. And the other one is really going to come through investigating what's happened in the case and researching that. And so really there is no advanced degree that's required in order to have a qualified expert witness serve as the qualified expert witness in a case. So, and we'll talk more about, but there are some things you're going to have to show on the record. So we'll talk about that as we go forward. Okay, so what we're really clear about is who cannot be the qualified expert witness. The qualified expert witness cannot be an employee of the person or agency seeking a foster care placement or termination of parental rights. And I put on there why. Why can't it be that person? Well, because it would show bias, basically. If someone from the agency that's seeking the placement came and served as a qualified expert witness, that doesn't satisfy this extra layer of evidence that the court needs in order to determine that this foster care placement or termination of parental rights is appropriate in the case involving the Indian child. So, as you move through a case involving an Indian child in the child welfare system, you have to always be thinking about where did this requirement come from and why is it there? So if the requirement is there because agencies were removing children historically based on institutional bias and cultural bias, having someone from that same agency come and say, yes, this is an appropriate placement and removal, or it's appropriate to terminate parental rights, it doesn't do anything to offer any extra evidence. And that's really what we're looking for. Evidence to ensure that the foster care placements and termination of parental rights that are happening in Indian Child Welfare Act cases aren't happening because of institutional bias. And this has been specifically answered by law in California, and that is because for several years, this was common practice. Many counties were actually using social workers who were not necessarily assigned to the case in court, but who worked at this same exact social services agency to come in and be their qualified expert witness. And so, again, a lot of tribes objected in court to this. It was clarified that it cannot be an employee of the person or agency seeking the foster care placement or termination of parental rights.
So, Christine, we jumped out a minute. So, basically, what you were saying is it used to be that counties or agencies were sending in other social workers that weren't necessarily on the case, so there wasn't a conflict of interest there, but that they were from the same institution, so to speak, the same agency. So they had the same institutional bias as the social workers who were recommending removal or placement that deviated. And there was enough cases where tribes and families were objecting to this, saying you're not addressing the institutional bias, that it became a law or case law, is what you said, case law, that you cannot use someone from the same agency recommending the removal to serve as a qualified expert witness. Is that correct?
Yes, that's correct, but I believe this has also been put right into the Welfare and Institutions Code. So
Okay.
While we don't have really specific definitions of who can be the qualified expert witness, we definitely know now by law it cannot be an employee of the agency seeking the placement or termination of parental rights. So that one is a settled question, which is great for those of us who are out there in working in the law to try to get more of these questions settled. And this one, I think, was answered correctly because of just what you said. Someone from the same agency is going to share the same institutional biases. So that doesn't satisfy the purpose of the requirement. Any questions on that?
We do not have any questions.
Okay, I'm going to keep going. All right. So, tribal social worker as the qualified expert witness. And by now, most of you have probably figured out QEW is an abbreviation for qualified expert witness. Can the tribe's social worker or tribal representative provide the qualified expert witness testimony that's needed in an Indian Child Welfare Act case? And the answer is that it's not prohibited. And that's a legal way of saying, sure, yes. However, and this is my personal opinion, it's also not ideal. So here's why I don't feel like it's ideal, although I know that there are cases where it's absolutely necessary. So it's almost impossible if the tribe doesn't have an attorney in court representing them, it's almost impossible for a tribal social worker or the tribe's representative on a case to handle direct and redirect and cross-examination in court. So basically what that means is when the tribal representative is up on the stand, and this was something that was asked earlier, who is going to object when questions are being asked of that person as they're qualifying themselves? And who's going to object if they're being badgered and asked questions? You would basically have to be on the stand and also managing the cross-examination. You'd also have to manage your own direct examination. So it would be the duty of the witness to get themselves qualified without anyone asking them questions. They would need to just each about qualifications. Say, I've seen this done expertly by tribal representatives in the past, but I've also, been there in court as an attorney and been able to step in, when needed. So I, can only imagine what it's like in court for a tribe without an attorney, because anytime I was there, I was acting as the attorney. But I've heard from other tribal representatives that it can be challenging. Additionally, if you are the tribe's representative or the tribe's social worker, and you do choose to provide the expert witness testimony that's needed in order to justify the foster care placement or the termination of parental rights, it can be seen as aligning against the parents in open court. And so the question is, does that cause a conflict? I don't think there's any legal conflict, certainly, for a tribal social worker or a tribal representative to go ahead and be the expert witness. But I will say, I think it'll be difficult if your goal is to work with that family down the road and be seen as an ally if you stand up and provide the testimony that is required to justify the foster care placement or the termination of parental rights. Additionally, what if the agency is actually contracting with you and paying you as the tribal social worker or representative to provide that necessary testimony? What does that, say to the other parties in the case about whose interests you really represent? So I'm not saying it's something that's illegal. I'm not saying that it will necessarily hurt a case, but I do think it can be problematic. So if there's someone else that can serve as the qualified expert witness, I think that is preferable because of the reasons that I stated. So is there any question around that issue, or any discussion even about using the tribal social worker or the tribe's representative as the qualified expert witness?
Yeah, we have a question.
Or is everyone just asleep from lunch? Are we in a food?
Oh,
good.
We do have a question. We're moving the mic over there.
Hi, Christine. This is Mark V.
I was
from...
worried there was like a food coma going on.
Well, there is that too, but I had this question before lunch. I know of some tribes that they do not want to provide the expert witness because they feel like it's almost helping the agency do its job and carry its burden. So I was wondering what you thought of that.
I agree. It is helping the agency do their job, because the agency is required to have this testimony before the court can make orders for whatever action it is the agency is recommending. So this is the agency's burden to provide that testimony. And so I could see where a tribe would feel that they need to stay really independent from the agency as a separate party in the case. And that definitely makes sense to me. But like I said, I'm not condemning tribes who do use their tribal representative, because sometimes that's the best qualified person to provide the testimony.
Okay.
I just have a comment. The thing to remember about expert witnesses is what they review and rely upon is not privileged. It's not secret. It's not confidential. So anyone can ask an expert about anything they relied upon. And a tribal representative putting themselves in that position then puts into play anything and everything that they relied upon. And you can get lucky and nobody will ask you, but if you've had sidebars with the council, or you've received documents, or you've talked to the parents, each and everything that an expert witness, once they're qualified, is discoverable. So it's not a situation where you can really hide the ball.
So for,
I think that's an excellent point. And I think the line could easily blur in a case of where did your preparation for the testimony start? And tribal social workers may have been involved in the case even before the county intervened and filed a petition in state court. So I think that's a really excellent point and something to keep in mind. And again, it's just another example of why I think it's problematic, but it's definitely, it's allowed. I'm just not sure it's best practice in every case.
so Christine, just to clarify, and most of you probably don't need this clarification, but
Is there
just in
anything
case.
else?
Yeah, hold on, Christine.
Okay, we have more to cover, so
Wait, sorry, I muted the wrong time. I just wanted to clarify for the non-lawyers, because we got a little lawyerly in that discoverable discussion of tribal social workers. So what was basically happening is we were discussing if a tribal social worker is qualified as an expert. The advice is it's not the best, but sometimes it's necessary. Sometimes it's the only option you have. There's reasons that you feel you need to have a tribal social worker qualified as the expert. What Mark was pointing out and Christine confirmed is the additional problem with doing that is that confidential discussions, things that otherwise nobody in the court would have the ability to hear about, those become the public record. Those become things that the other side can use against the tribe or the family or whoever you're representing as the qualified expert witness. They can get to that information then. So an additional problem with having the tribal social worker qualified as an expert is you open the door from an evidence standpoint to evidence that otherwise would have been held confidential. That about right, lawyers? Yeah. Does that kind of clarify? It seemed like some of you seemed happy to hear that clarification. Does that make more sense now? So that's another reason you don't want to do that, because social workers are going to be privy. They're going to have access to information that a qualified expert witness wouldn't otherwise have. But when they become a qualified expert witness, that information becomes open to all. Okay, sorry. Continue, please, Christine.
thank you, and thank you for that clarification. And I welcome that. Anytime the discussion is not clear or too lawyerly, please jump in, because this needs to be clearly understood by everyone. Okay, so now that we've talked about who can be an expert witness and who cannot be an expert witness, and who is what's best practices around who should be an expert witness, now we can talk about the duties of an expert witness, including compensation, duty of potential experts, and procedure for preparing for your testimony. So, compensation. This may seem strangely out of place, but it's something that I've dealt with a lot on a practical level. The burden is on the agency or person recommending the placement or the termination of parental rights, and that's TPR is abbreviation for termination of parental rights, to secure and pay for the expert testimony. And that was something that we already had addressed by one of our attendees. It is the agency's burden to find this person and then to pay for their expert testimony the way they would pay for any other expert testimony in any other case. And just to be clear, expert witnesses are used in all different types of cases in California and throughout the nation. And they're almost always compensated for their time preparing and also for their time testifying in a case. So what if the expert is a member of the tribe or an employee of the tribe? And I put these questions in because there were definitely times when I was working on a case and the expert witness was a member of the child's tribe, and the agency felt like they didn't need to compensate that person because it was their duty as a member of the community to come forward and provide this expert witness testimony. Same thing with an employee of the tribe. So I wanted to just see if there was any discussion around that before I revealed my answer, although I'm sure you can all look down at the slides and see it. But how does anybody feel? Do you think that if someone is a member of the tribe or an employee of the tribe, that they should be compensated for their expert testimony? And why?
Anyone have an opinion on that? They're all being very quiet, Christine. They read your response.
Cheaters.
Has anybody had an experience where the tribe basically said, okay, well, you're a member of the tribe, this is your duty, or you're an employee of the tribe, this is your duty, where that actually happened, and it would be difficult to insist on compensation? Like, we can discuss that as well. Show of hands. Anybody had a situation where the tribe was like, it's a member of the tribe or an employee of the tribe, we shouldn't have to pay them, it's their duty? Okay, we have a couple show of hands. So it has happened. Any thoughts on that? Do you think it's something if you said, hey, I went to this training, and they said we really do need to compensate them if they're working as a qualified expert witness? Do you think that might help with that argument? Karen's. See, I got someone to comment, Christine.
You're good.
They just want me to shut up.
No, I haven't looked at the answer yet, but I don't know if they should pay the individual if they're working, but definitely compensate the program or the social services
Is there
program.
a comment
that they're
coming?
from.
I can't hear anything.
Sorry.
You can repeat it for me.
Yeah. Karen did answer it very well. She was saying that even if they don't want to compensate the individual, the tribe should at least compensate the program that they work for. So she kind of agrees with the understanding that you need to compensate a qualified expert witness, and if it's a member or an employee, if you don't compensate them as an individual, you should at least compensate the program or the department they're working for, and their expertise being utilized by the tribe.
Yes, I would agree with that. And so I think the best advice I can give is that in any case where a qualified expert witness is needed, the same compensation should at least be offered to whatever expert is going to be used. And then if the expert either cannot take compensation because of the nature of their work or doesn't feel that it's right for whatever reason, then that can be, negotiated between the expert and the party that's seeking to secure them. But at a minimum, I think that it should be offered because this person is going to be taking time from whatever schedule it is they have to come and provide expertise on a case. And there's also time involved outside of court doing the preparation that's required to gain the knowledge to be able to testify in court. So I just bring that up because I think this practice has really improved over the last few years. But there was definitely a time where the feeling was, hey, it's your job as a tribal member. We shouldn't have to compensate you. And so I think that agencies are really getting better about that. I hope. That's been my sort of anecdotal analysis there. Okay, so contracts. I really recommend that everyone who's going to serve as a qualified expert witness has a contract, a written contract that lays out the details of, one, their compensation for their preparation. Are they going to be paid by the hour? Are they going to be paid by a flat fee? We've already talked about the fact that you don't have to be compensated if you don't feel that it's appropriate for you. But if you are going to be compensated, you should have something that lays out how that's going to work. Also, the compensation for the actual testimony. Again, are you going to be paid by the hour or are you going to use a flat fee method? I point this out because if any of you have ever been involved in any kind of a court case, whether it's a juvenile case, an Indian Child Welfare Act case, or some other case, you know that court proceedings can run behind, they can be delayed, and they can also run very long. So you should think about what happens if I'm supposed to be there at noon, but our case isn't called till 3. Also, what are the expectations for the qualified expert witness? What is the procedure if the qualified expert witness finds, after they've done their investigation and done their research on this case, that they do not support the recommendation for removal or for termination of parental rights? We'll talk more about this later, but I think that there should be some kind of clause in a contract that says what will happen in terms of our contract, in terms of compensation for the time that's been put in to researching the opinion, if at the end of the research, the person who was approached to be the qualified expert witness cannot provide the testimony that the agency is seeking. And then finally, I think contracts should have some kind of language about confidentiality and how documents, reports, interviews will be treated when the case is over or during the case. So those are sort of the minimums, I think, that should be included in a contract to protect both the agency seeking the expert and also the qualified expert witness themselves. Okay, so preparing the opinion, and this is something that I've said we're going to talk about later, so we're here now. There is preparation that goes into forming an expert opinion that will be used for the qualified expert witness testimony. So what do you need to do to formulate an opinion after your research? Well, you need to review the case file. So that means, potentially everything that's been filed with the court, reports, pleadings, anything that's in the court file that can provide evidence, because that's going to show you what the court knows, and it's the court that needs your testimony. So going back to, again, why is this here? The court can't order foster care until there's that testimony from an expert witness that the foster care placement is required. So you need to look and see, is there evidence in front of the court that they can make this order legitimately? The second thing, you can request service logs from the county agency, the social worker, and that's going to show you additionally more information about what's going on in the case, what services have been offered to the family, to the parents, and potentially to the child in the case, and what's resulted potentially from those services being offered. And then finally, and this is definitely last but not least, it's my recommendation that anyone who's going to be providing expert witness testimony should conduct their own independent interviews. They should attempt to interview parents, other family, including siblings, if age appropriate, tribal social worker or other tribal service provider that may have been involved with the case, and then the minor's representative and or the minor or minors. And so it may not be possible to conduct all of those interviews. Parents may refuse to meet with you. Parents may be completely absent from the case altogether. Again, there may not be any extended family that's been involved with the case, but the important thing is that you attempt to speak with these people and that your attempts are documented, because you're creating your own record of what you've done to prepare your opinion, and potentially you can be asked about that in court when you're on the stand. So document all of your efforts to review these files, to conduct these interviews, and then also document what you've discovered through reviewing these documents and conducting the interviews. Additionally, I really recommend that interviews with parents, families, social workers, minors, that those all be in person when possible. And again, there may be reasons why you're unable as an expert witness to conduct these interviews in person, but in-person interviews are really preferred. And if you cannot conduct an interview in person, I think it's important to document the reason why. So if it was a distance issue, if the person was unavailable due to scheduling, work, some sort of medical reasons, maybe they were in a inpatient treatment facility, document that so that you can put that into your report to the court. Okay, so preparing your report, it's important to have some kind of document of what you've done to prepare for your testimony. I recommend a report or a declaration, preferably in writing. And declarations seem to be what are commonly used by a lot of qualified expert witnesses in cases in California. And so what that is just a written document saying who you are as an expert witness, what you've done to research the case, and what your opinion is. So that's exactly what you want to include. What are your qualifications to provide this opinion? And if possible, you should really talk about how your qualifications are specific to this child's tribe. What research did you do to prepare for your opinion? Did you review the file? Did you interview anybody in person or by phone? Did you interview anyone about the tribe's cultural standards in order to prepare? And then finally, you do need to include in your report whether or not the removal or termination of parental rights is justified in the case, and then why or why not is also helpful. But you have to have that specific language that the continued custody with the parent or Indian custodian will cause emotional or physical harm to the Indian child. Are there any questions on reports, preparing for reports? We're going to do more in terms of an exercise later, but I did want to see if we have any questions at this point. What should you do to prepare?
Any questions on preparation? Any question at all from what we've covered thus far? Okay. Looks like we don't have any questions.